Hello and very good evening, everyone. I hope that everyone are doing great and still staying safe wherever you are now, at homes or are you still at the office or any part of the world now. By the way, my name is Ami. I'm from the Excel Academy, and today I'm pleasure to be your moderator of tonight session of the Strata Talk Show. On behalf of Excel Academy, I would like to thank you and welcome everyone to our very first Strata talk shows. And we appreciate your times after a busy day at work to join us tonight. And tonight, on our very first episode, we will be talking on a very interesting topics on the strata property management, which is attendance and votings in meetings. And joining with us today, our very respected speaker, Mr. Patrick Samuel Sebastian, advocate and solicitor of the High Court of Malaya. Hi, Mr. Patrick. How are you doing today?
Okay, very good. Thank you, Mr. Amir.
Thank you, Mr. Patrick, for your time joining with us today and sharing with us today on these very interesting topics. So before I pass to Mr. Patrick, I would like to share that if you have any question to ask to Mr. Patrick, you can write your question on the Facebook comment below, and hopefully Mr. Patrick will answer during the Q&A segment later at the end of our session later. So I think without wasting more time, please join me in welcoming Mr. Patrick.
Okay, thank you very much, Mr. Amir. Good evening to all of you all. Thank you for taking some time off. This is our talk. Uh, I would not know how you would like to call this talk. You can call it Walk and Talk the Strata. This is just our Strata talk. And while we were discussing with Excel Academy about based on our seminars and CPDs and webinars which we have conducted, we find that the most pressing issues nowadays is focused on the meetings that take place at either JMB level or MC level. So we have these meetings that take place. And these meetings are the focus of attention simply because the meetings is the place where decisions are taken. Now, although a JMB or a MC is regarded as a corporate body, so in many ways they are treated just like a company, we need to understand that there are corporate decisions which will become binding on all parcel owners, irrespective of whether they agree or they disagree to the decisions or resolutions taken at these meetings. So, when you become a member of a JMB or MC, you do not choose to become a member, but you are automatically co opted as a member by virtue of being a parcel owner or purchaser. Therefore, you become a member. Now, when you become a member, we have to realize one thing. I always say this. When it comes to land law, they say an Englishman's home is his castle. Your home is your castle. In other words, you are the king of your castle. You can do what you like. Whatever color you like to paint your house, you can paint your house, things like that. However, when you stay in a stratified property, that phrase does not apply. You're not the king of your castle. You cannot make decisions as you like. For example, you cannot paint your house, whatever color you want. There are restrictions, there are limitations. Not only that, decisions are taken corporately, meaning the majority wins. And if the majority wants to maintain the stratified property or development in a certain manner, then you either agree with them or you may have to sell out and move out. So there are corporate decisions, and these corporate matters are decided at two levels. Level number one, they are decided at the committee stage. The joint management committee, the management committee, they have powers to make certain decisions. The law is very clear about that. If you look at the statute says that the JMC, for example, can exercise all the powers of the JMB on behalf of the JMB. So certain decisions are made at JMC levels. Certain decisions are made at the corporate level, JMB. This is where you talk about meetings, and as a parcel owner, you have a right to attend the meetings, you have a right to vote at the meetings, you have a say on what happens at these meetings. Nevertheless, it does not mean that your say must carry. Your say may not be shared, your opinion may not be shared by others in the group, and in such a situation, you may have to sort of submit to the majority decision. Having also said that, I must add there are certain rights of a parcel owner which are personal in nature and which cannot be removed by any kind of resolution. So, there is a line to be drawn between the decisions taken at the JMB or the MC, decisions taken at committee levels, and what are your individual rights. Now, without going into too much details, let me just give one example. For example, nowhere in the Strata Management Act, nowhere does it provide for an in-house resolution of conflict between parcel owners. Let me repeat that. Nowhere in the Strata Management Act is there a provision to resolve a conflict between parcel owners. If the conflict arises because of the building, that is a different story. For example, you talk about interflow leakages, that is regarding the building. But let us say, for example, the complaint is about the owner next door, about his behavior. Maybe he's making noise. There's been some amount of nuisance. And there is some argument or misunderstanding between one owner and the next. This cannot be resolved. I wouldn't say this cannot be resolved, but there is no mechanism for resolving this within the Strata Management Act. So this you will also notice that when you bring a case to the Strata Management Tribunal, one parcel owner may not sue another parcel owner at a personal level. Only if it concerns the building, for example, like interfloor leakage, as I mentioned, or some kind of renovation works which you have done without authorization, then and then only you can bring an action, or the JMB or the MC can step in and look into it. So we have to keep this in mind. So let's not get carried away, especially if you're a JMB member, if you're an MC management committee member. You must realize there are limits to what the JMB or the MC can do. Additionally, keep in mind the JMB, the MC are statutory bodies. They are constituted by statute. They are regulated by statute. So their powers must fall within the four walls of the statute. They should not do anything which is outside the four walls of the statute. They must try, insofar as it is possible, to act within the four walls of the statute. Of course, the statute is not perfect. There may be many gray areas. This is where, as a committee member, you take certain risks in making decisions where it is regarding gray areas. So as we go along, the court cases come and the courts make decisions, not necessarily all the time correct decisions, but we have to respect the courts. Ultimately, policy decisions must be made by Parliament. All right. With that as a basic introduction, we look at the dynamics of a meeting. There are two particular dynamics that we are looking into in today's talk. One is attendance at general meetings. Now, as a rule, the JMB and the MC are two different bodies. The JMB constitutes of parcel purchases. They are people who have purchased their parcels but who are not yet in possession of strata titles. Some may already have obtained it, but if you have not reached one-fourth of the aggregate shares, then the JMB will continue to function. And those who attend such meetings are the parcel purchasers. In an MC, on the other hand, you would have hit the one-fourth share units, and quite a number of them will be in possession of their strata titles. So attendance is determined by whether you are a parcel purchaser, number one, and number two, whether you have strata titles. Now going further from there, as a purchaser, there are other factors to take into consideration. Number one, are you a corporate body, or are you a society, or are you an association? As one. Two, are you a co-owner? It could be husband and wife. It could be within the family, siblings. You could be that kind of person. Or you could be just the sole proprietor, the individual owner. Now, if you are a company or an organization, then you would attend the meeting by way of a representative. And in order to be a representative, you should have the proper letters of appointment appointing you to attend the meetings. In the absence of such letters of appointment, the committee will be perfectly all right to deny you entrance into the meeting, let alone vote at the meeting. So you should have proper letters of authorization appointing you and identifying you sufficiently, IC number perhaps, so that you will be able to attend on behalf of that organization. Alternatively, some organizations will appoint their representatives by way of agency. They want to appoint them as their agents. Now, if you appoint them as agents under seal, this means you need to come with a power of attorney. There will be a power of attorney which you must produce so that you will be entitled to attend the meeting and vote at the meeting. So this is for organizations. Now, if you are a co-owner, of course, then you can always attend a meeting by virtue of being a co-owner. And if you're a sole proprietor, there will be no issues whatsoever regarding your attending the meeting. So this is the first part. Now, there used to be a confusion about the fact that people who have not paid their maintenance charges, people who have not paid their sinking fund contributions cannot attend a meeting. However, that is not stated in the Strata Management Act or in the rules, right? What it says here is that if you are owing or if you're in arrears of your maintenance charges and sinking fund, then you can be barred from voting, number one. And number two, you may not stand for election as a committee member. So you cannot be voted as the president or chairman, the treasurer, the secretary, or any other committee members. But you can still attend the meeting. Now, so we are clear about that. However, although you may attend the meeting, uh, you will not be taken into consideration. In other words, for the purpose of a quorum, the law is very clear. Regulation number 15 of your Strata Management Act, the regulations in the second schedule says one half of the proprietors entitled to vote present either in person or by proxy shall constitute a quorum. So it says one half of those who are entitled to vote. So if you have not paid your subscriptions, your management fee, you are not entitled to vote. So we need to take note of this. This is the first point that we have to consider. Secondly, right? So this is regarding attendance. Who can attend? Who can organizations, individuals, co-owners who are coming in, and those who 7 days before the meeting have not settled all their arrears, then they cannot attend. And for this purpose, right, for the benefit of all who are going to attend the meeting, the law requires in Regulation 14 that the management committee must put up a list of those persons who are entitled to vote at least 48 hours prior to the meeting. So everybody will know whether they are entitled to attend and vote at the meeting. So this is as far as the attendance at meetings are concerned. Now, a very interesting question to arise, interesting point to arise, which I'll consider, is can the chairman bring in any person who is not a member to attend the meeting? For example, I have attended several meetings when I've been invited by JMBs and MCs when controversial decisions are going to be made, resolutions which are likely to evoke a lot of questions are raised. So I attend. Generally, nobody has objected so far. But I'm wondering, there's nothing in the act to say that we can get anybody to attend the meeting. Strictly speaking, only parcel owners are supposed to attend the meeting. So can we bring in lawyers to attend the meeting to advise? It's food for thought. I suppose nobody has challenged it as yet. I remember when I attended an EGM in 2019 and 19 USJ, there were two lawyers present to give their opinions about car parks. I was invited by the committee, JMC, to give my opinion, and another lawyer was also brought in and she gave her opinion. So to enable the attendants, those who are attending, to discuss about this, to make a decision. Likewise, can we invite others to advise on certain issues that may arise? Maybe buying property, maybe telling us the procedure for doing certain things. So you may want to check this out, whether this is actually allowed or not. I would think there should be no harm so long as the so-called expert or guest who is invited is not allowed to sort of hijack the meeting and take charge of the meeting, but that they will just give their opinion, and then they will have to leave when decisions are being taken by those who are present there. So this is a very interesting point for us to consider, right? In a company, for example, when you have your AGM every year, the auditor is invited to attend the AGM, and should any questions arise on the audited accounts, the auditor will give his answer. But no such provision is made for GMB meetings or MC meetings. Although I'm sure there'll be no harm in inviting such persons to attend and speak. Okay, that is regarding that. Coming next to the next point, and that is the voting. Now, the voting is number one. Is two. First question is, who are entitled to vote? Who is entitled to vote, and what is the manner of voting? Now, entitled vote again goes back to the three basic issues of whether you are a corporate representative, whether you are a single owner, or whether you are a co-owner. Now, if you are a corporate representative, of course, you can vote on a show of hands. You can vote on a poll as well. If you are a sole proprietor, there's no issue about you voting. You can always vote on a show of hands. You can also vote on a poll, which is based on your share units. If, on the other hand, you are a co-proprietor, as a co-proprietor, you are not allowed to vote on a show of hands. The regulations very clearly provides that in a show of hands, the co-proprietors must either choose a proxy to vote on their behalf, or alternatively, the co-proprietors can choose one of their number to vote, right? To vote. So either you choose a proxy to vote, or you choose one of their number to vote. This is a procedure. Now, as you can see, most of them can choose proxies. Again, comparison with company law is a little bit misleading, because in company law, a proxy generally can only vote on a poll. He cannot vote on a show of hands. However, in a GMB meeting or in a management corporation meeting, the proxy can vote both on a show of hands as well as on a poll. He can actually vote on both. So now, who can be a proxy? Anyone can be a proxy. A proxy does not have to be a parcel owner. But there's no law saying parcel owner cannot be a proxy. So you can choose a parcel owner to be a proxy, in which case he will have two votes, one for his own parcel and one as a proxy. However, a proxy can only be a proxy for one parcel owner and not more than that. So please take note for developers who are still having unsold units in the project development, they can always vote, and the number of votes they have will depend on the number of unsold units which are still in their name. So if there are 10 units, they will have 10 votes on a show of hands, and depending on the share units, they will have that number of votes on a poll. There are cases where developers have asked people to nominate them to become proxies, so that they can continue to have control of the project development area. So, is this allowed? At one time, yes. Now, no. The law is very clear that a person can be a proxy only, okay, for one person and not more than one person. All these are found there, okay. in regulation number 17, regulation number 18, sorry, it says in sub 4, a person may act as proxy for only one proprietor at any one general meeting. Okay? And the proxy form has to be deposited not less than 48 hours before the meeting, in which case, if it is any later than that, it can be rejected. Okay? It can be rejected. So basically, this is what happens. Next, we come to the decisions that are taken. Of course, decisions that are taken are called resolutions, and we have various kinds of resolutions. We have the ordinary resolutions, we have special resolutions, we have what we call unanimous resolutions. So, different types of resolutions apply for different types of requirements. So, what is important? The court is quite particular about certain things, and the law is also particular about certain things. That is, in a corporate body, one of the key rights of any parcel owner is the right to vote. In fact, it is the right to speak at a meeting. Although we find that in most meetings, there are some people who will always dominate, but people must be given the opportunity to speak. People must be given the opportunity to vote. And if for a wrong reason, your proxy is not allowed into the meeting, or your proxy is not allowed to vote, or if your request for a vote by poll is not granted, then you may challenge this in the courts, you may challenge this in the tribunals. This is your right. We had this experience in PJ Center Stage, where the court ruled that the request of the parcel owners for voting by poll, which was turned down by the committee chairman on the ground that being an old development prior to 2013, the what we call the share unit, the conversion from square feet to share units had not been completed or was not correct. There were errors in it, and it had been sent back to the land office for correction. And on this ground, he said we cannot have a voting by poll because the share units are not accurate. If we follow the old law of going by square feet, the courts have ruled that it's not legal anymore. You cannot go by square feet. If you go by share units and the calculation is not correct, we will fall foul of the law. They inquired from the PJ Commissioner of Oaths, a Commissioner of Buildings, who agreed with the committee chairman, who said, yes, since the share units are not accurate, let's go by voting by show of hands. Poll cannot be conducted. The court said that was the denial of a basic and fundamental right of a parcel owner. Every parcel owner has a right to request for a poll as per the statute. It is the duty of the committee to ensure that the votes are taken appropriately. Also, if you look at the jurisdiction of the Strata Tribunal, the jurisdiction of the Strata Tribunal includes this very important thing, that is, the Strata Tribunal jurisdiction includes dealing with meetings dealing with resolutions for meetings, and in suitable cases, even to the extent of nullifying resolutions passed at meetings. So, we need to be very careful about the kind of resolutions that are passed. Resolutions can be nullified if they do not comply with the requirements. Meetings can be nullified as well. So be careful, because these are the areas where people have the right to make decisions. How else are they going to decide? The law does not allow individuals to make decisions in a stratified property. So you need to go back to these meetings, and the Strata Tribunal will assist in this area. Let me just run through to you the jurisdiction of the tribunal, which is put in the fourth schedule to the Strata Management Act. Item number 4 says a claim for an order to convene a general meeting. A claim for an order to convene a general meeting. That means if for some reason a meeting is not being held, then you can go to the Strata Tribunal, ask them to get an order to convene a general meeting. Number 5, a claim for an order to invalidate proceedings of meeting where any provision of the Act has been contravened. So if any provision of the Act has been contravened, then you can go to the tribunal and say, look, there's a contravention. This nullifies the meeting. Number 6, a claim for an order to nullify a resolution where voting rights has been denied or where due notice has not been given. Number 7, a claim for an order to nullify a resolution passed at a general meeting. Number 8, a claim for an order to revoke amendment of bylaws having regard to the interests of all parcel owners. So, specifically, items number 4, 5, 6, and 7 touches on meetings. And you can go to the Strata Management Tribunal. You can ask them to nullify the resolution if voting rights has been denied or where due notice has not been given. 14 days, 21 days, 28 days, the proper notice has not been given, depending on the kind of resolution that is being proposed. Okay? So, you can also claim for an order to nullify a resolution. Now, this is all what happens in an AGM or an EGM. So, these are things that happen there. Now, let me for a short while move to another one. Committee meetings. Committee meetings are not so well regulated by the Act because the Act says a committee may decide to regulate its own proceedings. It is the committee that chooses its chairman, treasurer, and secretary. Any appointment of a treasurer, etc. The regulations provide that if there is non-compliance with the law, for example, there is, let's say, a chairman or a secretary or a treasurer are disqualified from acting for any reason, nevertheless, the resolutions passed at the committees are valid and binding. The only requirement in the Act, in the regulations, is one particular thing, and that is the committee must have acted in good faith. If the committee acts in good faith, then the decisions shall be valid and binding. It is in the regulations. So if you're going to challenge a decision at an AGM or EGM, it's more easy because you can go to the tribunal and you can say procedures were not observed. But if you are going to challenge decisions at committee levels, let's say there's infighting within committee and you want to challenge, you'll find it a little bit more difficult because number one, the committee is allowed to manage its own affairs. Number two, decisions and resolutions passed at the committee are regarded as valid, even though there may be some kind of irregularity that takes place. So we need to keep this in mind. Okay, so far I've spoken about the important things, touching on attending meetings, touching on voting rights. At this stage, we are almost 40 minutes in. We have another 20 minutes to go. I would like to see whether anybody has got any questions. If you have questions, please put forward your questions to Mr. Amir, and Mr. Amir will see and we'll see what we can do and how to answer these questions. Thank you.
Okay, thank you so much, Mr. Patrick. Okay, now we are on to the Q&A segment, and we can see there is some question coming from our participants. Okay, maybe I will show the first question first, Mr. Patrick. The
Yep.
question is coming from Mr. Lee Chin Yao. Thank you so much for the questions. For co-proprietor owner, if only one of the co-proprietors sign for proxy, is it valid or both co-proprietors need to sign?
Okay, that's a very interesting question. If you will give me just a minute
Sure, Mr. Patrick.
to answer the question. Now, regulation number 22 talks about this. It says co-proprietors may vote by means of a jointly appointed proxy or by appointing any one of them or any other person. So the question, Mr. Lee, is this: if only one co-proprietor signs, it is not valid. Because the words here are very clear. Co-proprietors may vote by means of a jointly appointed proxy. Unless one appoints the other as a proxy, then of course, if A and B are co-owners, then B can sign and appoint A. No issue. But if they're appointing a third party as a proxy, then both A and B must sign. Right? Now, the only time a co-proprietor can vote is on a poll. On a poll, a co-proprietor can vote according to his share. If he's a half owner, he gets half the share units. He votes according to his share units. But coming back to your question, both or more than two, three or four. I have a case in Bercham Noah where we have four co-owners. Now, in order to vote, all four of them must appoint a co-proprietor or appoint one of them as co-proprietor. Okay? For proxy, both must sign. Thank you. Okay, any other question?
Okay, the next one is from Duncan. And the question, any example of resolution which can be nullified?
Okay, any examples of resolutions which can be nullified? Okay. Now, offhand, let me give you an example from PJ Center Stage. As I mentioned earlier, in PJ Center Stage at the AGM, they made there was proposed a resolution to now this is before the Rajawali case came up. There was a resolution to reduce the maintenance charges for the shop lots. So this resolution at that stage, quite a number of them asked for a vote by poll. And as I mentioned earlier, the vote by poll was denied on the grounds that the share unit book register was not ready or had mistakes in it. So, after taking advice from the PJCOB, they proceeded. In fact, they passed the resolution to proceed. Listening to the advice of the COB, they said, shall we proceed with a show of hands? They passed a resolution, agreed to proceed with a show of hands, and then they passed the other resolution regarding the adjustment of maintenance charges. These were nullified. The decision to proceed and the decision to adjust the maintenance charges was nullified by the court. Okay, so
Okay.
that's one example. It can be nullified on the grounds that sufficient notice has not been given. It can be nullified that the correct number of persons had not voted. For example, special resolutions, you need a three-fourths majority, that you did not get a three-fourths majority, or certain people were denied their voting rights. It could be nullified. I may venture to say the other ground on which a resolution can be nullified is if it is done mala fide. Now, this is based on a very old company law principle that although in a company the majority always make the decision and the majority decision carries normally, nevertheless, when it comes to certain things in companies, for example, if you're going to alter your articles of association or you're going to alter the memorandum of association, then this old English case called Allen and Gold Reefs of West Africa Limited, decided in 1900, said that any voting done by the majority must be bona fide for the benefit of the company as a whole. So, in such cases, if a major decision is going to be taken by the JMB or the MC, something which touches on maybe the bylaws, the rules, or something which is quite fundamental, I would think that any decision taken must be bona fide for the benefit of all parcel owners and not just the individuals concerned. And in such a case, where you can prove, difficult though it is, if you can prove that it was mala fide, not bona fide, the resolution can be nullified. Yes, thank you.
Okay, thank you, Mr. Patrick. I hope Mr. Patrick has answered your questions. And on to the next ones. The question is coming from Mr. 𝐀𝐭𝐞𝐞𝐽𝐧𝐠. Hi, Mr. Patrick. I would like to ask if a management committee absent from 3 consecutive meetings, does it automatically deemed to have vacated his or her office?
Okay, that's a very interesting question. Okay, now it is provided for in the rules that regulation 3 talks about vacation of office, and in subparagraph H it says, in the case of the chairman, if he absents himself from 3 consecutive scheduled meetings of the management committee without the leave of the management committee. And paragraph I says, in the case of a member of the management committee other than the chairman, if he absents himself from 3 consecutive meetings of the management committee without the leave in writing of the chairman. Now, there are 2 different things. One is paragraph H, which talks about the chairman. It says, in the case of the chairman, if he absents himself from 3 consecutive scheduled meetings. So the meetings must have been scheduled and he absents himself from 3 meetings without the leave of the management committee. So if he has got leave of the management committee, absence with apology, then it's not automatic. But for others, it's just 3 consecutive meetings, not scheduled meetings, and without leave in writing. Then they vacate office. Okay? So it's quite clear that it is automatic, because it says here they shall vacate office or shall be deemed to have vacated office. And if you read further under that rule 3 sub 2, it says within 14 days of the occurrence of any of those events, they can appoint a replacement. So it's quite obvious that it is quite automatic, right? Because you are deemed to have vacated, and within 14 days, they can appoint. But make sure they follow the rules. Okay, thank you.
Okay, thank you so much. The next question is coming from Duncan again. And the question is, do you know about the legal right to have an EGMs, online EGM during this COVID seasons? For example, will it be illegal to have an EGM over EAGMs platform in place of a physical meeting?
Okay, this is an interesting question because uh, let me put it this way. In the Act, there is no provision for online meetings, right? In the Act, there is no provision. We had this experience in 19 USJ where the newly formed MC, having obtained police permit, decided to go ahead and have a meeting, an online Zoom meeting, their first AGM. There were complaints raised by some members of the JMB and other parcel members, and the COB had written to the MC stating that online meetings, virtual meetings, are not recognized by the law, and the COB refused to recognize such a meeting. However, early this year in March, there was a request made to the Kementerian Perumahan to allow virtual meetings. And because most of the JMBs and MCs would be falling foul of the law if they did not hold their EGM within the time. However, having said that, the Kementerian allowed for such meetings. They said adalah digalakkan untuk mengadakan, right, perjumpaan dan mesyuarat secara maya, virtual meetings. To this, we must add a number of things. The power to suspend any part of the Act, the SME, is given to the local authority. It is not given to the Kementerian Perumahan. Please, if you were to look at your Strata Management Act, if you do happen to have one in front of you, you will notice that in section 1 itself, right, it is provided in sub 7, it says the state authority may, if in its opinion would be in the public interest, etc., suspend the operation of this act or any provision of this act in any local authority area. So they can suspend by saying, all right, you do not have to hold your AGM, you do not have to hold your EGMs. They can do that, but that is done by the state authority. Remember, land comes under the state, right? Number 2, ministers are also given certain powers. But the powers of the minister is basically to, I would say, to sort of suspend any particular rule, right? To suspend any particular rule. Now, there have been a series of exemptions that have been provided. All these exemptions that have been provided actually are carried out by the minister and the powers given to the minister. The power to exempt, we call it under section 151. It is to exempt you. So the various exemptions that came were things like exemption from filing audited accounts, exemption from holding AGMs, and that exemptions were for developer, regarding returning money back, like common property defect accounts, returning the money, refunding of money, all these kind of things. There were exemptions given. The time frame, within which time frame they must do it, but no power is given to a minister to call for a virtual meeting. So that's a big question mark whether you can actually carry out a virtual meeting, because the minister does not have the power to do so, although the Kementerian has allowed it. Yes.
Okay, thank you so much, Mr. Patrick.
Maybe I will just add one more thing to what Mr. Duncan
Sure.
is asking. Unless this is tested in the court, because a very recent thing, unless it's tested in court, I cannot very affirmatively say this. What I can say is, looking in the law, the minister is certainly acting beyond his powers. Okay.
Okay, thank you so much, Mr. Patrick. Since we are running out of times, maybe I will get one last questions for tonight. And the question is coming from Kuswa Kurma under Section 76 SMA 757, Appointment of Administrator of MC. Can you explain that section, Mr. Patrick?
Okay. Now, the what we call it, management of a stratified property goes through many stages. Now, of course, the stage one is a developers management stage. Then the JMB comes in, transit, and after the JMB, the MC comes in. The only permanent body is the MC. Having said that, it is not always that management of stratified properties will run smoothly, or that people are interested in managing their property. Sad to say, attendances at AGMs and EGMs are very poor, much to the benefit of those individuals who like to dominate. Now, if there are suspicions of foul play, the most common suspicion being that money is being taken out from the sinking fund or from the management fund, maintenance fund. People are stealing money. I recently had a referral from Ipoh, where the new chairman has come in and he's discovered that the previous treasurer has been taking money out, and so they want to take action against him, which may be possible to prove only by having a proper audited accounts, or that contracts are being given to their own favorite people and being overcharged and things like that. Then one is to go to the COB. The COB has the power to appoint a managing agent to manage the place, in which case the JMB gets suspended. The JMC, the committee or the management committee will get suspended, and the managing agent takes over. The managing agent has to be an independent person. He has to pay a deposit as security, and then he will manage and he will carry out whatever terms the COB tells him to do, which will be probably getting audit done and things like that. Where we reach a stage of a MC having been formed, meaning people are in possession of strata titles, then any person can apply to the court to ask the court to appoint an administrator to administer the place. Maybe, let's say, again, you are claiming that there's mismanagement of funds, mismanagement of the place. Then you apply to the court may appoint an administrator, and the administrator will administer the place, report back to the court, and from the findings, all necessary action against wrong parties can be taken. I have filed one such matter, is pending in Ipoh at the moment, where amongst all, I've asked for the appointment of an administrator by the court. It's going to be heard, and the trial is coming up early next year, and we'll see how it goes. So that is appointment by the court, usually when embassy is already in place. All right.
Okay, thank you, Mr. Patrick. Maybe we can take one last question because we have another 5 minutes before 9 p.m. And Mr. Patrick, the question are coming from Ms. Fatiha. Hi, can an absent proprietor be nominated and elected as a member of a joint management committee or a management committee?
Okay, the answer to that is yes, he can, provided he has agreed to it. The regulations clearly provide that so long as he agrees to it, there should be no thing against it. However, if he has not agreed, then that cannot be done, right? So the basic thing is it can be done, but he must give his written consent to it. Only then, and then only this can be allowed. Just let me refer to the place where it is stated. Is that your rules? So you can just look at it. There is under the regulations. So it's not a problem for a person to be appointed, to be elected, right, to this post. So there are no issues against it. Just give me a minute. I'll just look for the particular rule just to guide the person there. I had referred to this in one of the cases that we did. So the court has held that it is valid, provided the person has given his consent in writing. Okay. Okay. Often I don't seem to get it, but so the general rule, of course, it will say that he cannot unless he has given his consent in writing. Okay. Okay, I've just got it. It is in Rule 2, Regulation 2, Sub 13. It says here, if I may read it, an absent proprietor shall not be nominated for election as a member of the management committee unless he has appointed a proxy and has given his written consent to be nominated and elected as a member of the management committee. So he must appoint a proxy and he must give his written consent to be nominated and elected, right, as a committee member. That's in Regulation 2, Sub 13 of your second schedule. All right. Okay. So that's my answer to that.
Okay, thank you so much, Mr. Patrick. I hope Mr. Patrick has answered your questions, Ms. Fatiha. Okay, guys, I think we don't have much time. Thank you so much, Mr. Patrick, for sharing your thoughts and view about our topics today, which is attendance and voting in meetings. And for the question that we didn't manage to answer, don't worry, you can join our next episode, which is our second episode next week, which is on the 14th October 2021, same time as well, 8 p.m. Okay, you can join us on our Facebook's live with Mr. Patrick. So I think that's all for us tonight. Thank you so much, Mr. Patrick, again. And thank you to all participants for joining our first Strata Talk Show tonight. With that, thank you so much. Hope to see you guys again next week. And a very good night.
All right. Good night to all of you. Thank you for joining in today. All right. Take care.